So let's discuss Companies Act questions. First question that is given to you in your context is, what is meant by a guarantee company? State the similarities and dissimilarities of a guarantee company and company having share capital. So we know that for a guarantee company, it is company limited by the guarantee of the people who are the subscribers, who are the members. Okay. So first similarity, you can say these are both limited liability, right? Whenever you will get the question paper, I guess you get 15 minutes before the examination to read the question paper. Is that so?
Yes.
Yeah.
Yes,
So whenever you have been given the question paper, if you know few things, see if the invigilator is nice, you can just write those things or you can just mention those points. You can keep it with you people. Okay. So first is your limited liability. That is the similarity. One is limited by share capital. Other one is limited by the amount guaranteed. These things you can remember and you can write. Dissimilarities we will be seeing over here. Okay. Now, company limited by guarantee. Section 221 of the Companies Act defines it as a company having the liability of its member limited by the memorandum to such an amount as the members may respectively undertake by the memorandum to contribute to the assets of company even in the event of being wound up. Simple language, how you will write it, defines that a company where the members have the liability limited by the memorandum to the extent they will be contributing when the company is being wound up. Simple words you have to write. Okay. No need to write entire complex thing. You just have to write, as per the Companies Act 2013, a company having liability of its members limited by the memorandum, then what you can write, of such an amount to the assets of the company, to contribute to the assets of the company in the event of its winding up, being wound up. Okay. This points as the members may respectively undertake by the memorandum. If you skip, that is okay. This, even if you don't mention that by the memorandum, that is also okay. You can write as mentioned in the memorandum. Simple words also you can use. Thus, the liability of the members of a guarantee company is limited up to a stipulated sum. If it is written in the memorandum, 5 lakh is the liability of every member, that will be the 5 lakh liability only mentioned in the memorandum. So for this, you can write liability of member of guarantee is limited to an amount written in the memorandum, to a stipulated amount or a fixed amount written in the memorandum. Members cannot be called upon to contribute beyond that stipulated sum. You can't ask for any other sum other than the amount mentioned. Simple words, you can't ask from members any other amount than written in the memorandum. Is the first point clear how we have to present? Now here I am explaining you the normal questions also, direct questions also, so that if we are going wrong with the provisions writing or quoting the answers, that time you will be clear with the simple questions also. Is this point clear how we have to present simple words?
Yes, ma'am.
Okay. Now, coming to similarities and dissimilarities. The common features between a guarantee company and a share company are legal personality. Both have the legal personality. They have a separate legal entity title and limited liability. Okay. Then, in the later, the member's liability is limited by the amount remaining unpaid on the share. In the second one, later means second. Share company, what is there? Amount unpaid on the shares. Amount unpaid on the shares. That is the liability which each member holds. So if I'm holding 10 shares and I have not paid rupees 3, so my liability will be only rupees 30. Both of them have state in their memorandum that the members' liability is limited. In both of the companies, their memorandum should consist that the members' liability is limited. Even if you write this much, this first point only, and then if you remember, you can explain it. Even if you write this much, that is correct. The basic point is clear over here. And whenever we write for share company, we have like read it so many times that it's on our lips. We can just easily say that. In the case of company limited by shares, the amount that is payable is your unpaid amount on share. Then both of them in the memorandum, it should be written limited. This is also a very simple line which you can remember. Both of them have to state in their memorandum that the member's liability is limited. Okay. Similarity is clear?
Yes, ma'am.
Okay. However, the point of distinction between these two types of companies is that in the former case, members can be called upon to discharge the liability only after commencement of winding up. I had explained you, guarantee company, you can call the members only on winding up, right? Only on winding up. But if it is limited by shares and your company needs money, you can call the shareholders. You can tell them, give us the amount. So if like me, there are 10,000 people who have not paid the money, rupees 3. So this company can get 3 lakh rupees. It is in need of 3 lakh. It can get 3 lakh easily during the lifetime of the company, right? But in guarantee company, you can call the members to pay only on winding up, only on starting commencement of the winding up, and only subject to certain conditions. You have to follow, you have to comply with certain conditions. But in the later case, that is your share company, they may be called upon to do so at any time, either during company's lifetime or during its winding up. If you have a company limited by shares, you can call during lifetime, during the lifetime, or on winding up. Okay, is this clear to you people? Is this point clear?
Yes, ma'am. Yes, ma'am.
In the former case, members may be called upon to discharge their liability only after commencement of winding up. And you can say in the later case, they may be called upon to do so at any time, either during the company's lifetime or during its winding up. Okay, anytime you can call them. I hope this question is clear to you people. Is this question clear? How we have to present the answer, is it clear to you people? Okay, let's go ahead. Let's see the next question. Now, next one is, can a non-profit organization be registered as a company under the Companies Act 2013? If so, what procedure does it have to adopt? Now, we have seen section number 8 companies, right? Now, yes, a non-profit organization to be registered as a company under the Companies Act by following provisions of Section 8 of the Companies Act. This section you have to remember. I am telling you, no section you remember, just this section you have to remember, that for a non-profit organization, you have Section 8. Okay. In the Companies Act, you have Section 8 specifically given. Now, what does Section 8 tell us? Section 8 of the Companies Act deals with formation of companies which are formed. Why are these companies formed? Which type of companies? Which promote the charitable object of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment. Whatever charity things we do, commerce, art, science, education, hospitality, religion, your temples, etc. All this you can write. Simple words. Hospital, then you call it as social welfare, research work, then you call it as charity, temples, environment protection, saving the forest, etc. All these things you can write. They are promoting this type of objectives. Such company intends to apply its profit in promoting its objectives. Why? What are they going to do? The profits where they are going to use? They are going to promote its objective. Prohibiting the payment of any dividend to its members. You are not going to allow any dividend payment to the members. Why are you working in this company? Because you want to give something to society, not to the members. Members who are paying over here, who are the members of the company, they are not going to get anything. This is just done for other people, social work. Central government has the power to issue license to registering the Section 8 company. So you have to go to central government to ask for the license of this company. Section 8 allows central government to register such person or association of person as a company with limited liability without the addition of words limited or private limited to its name by issuing a license of such conditions as it deems fit. So Section 8 gives central government the permission to grant a license to the company. And in this company, if you want, you can write the words limited, or else without the words limited also, it can be given a license. This is how simply you will present it. Registrar shall on application register such person or association of person as a company under this Section 8. So you have to write, these people who want to make a Section 8 company need to get themselves registered, okay, with the registrar of companies. On registration, the company shall enjoy same privileges and obligations of a limited company. So your Section 8 company is equal to as limited company, right? A limited company, your normal company, private limited company kind of. Clear, everyone?
Yes, ma'am.
Yes, ma'am.
Okay. Briefly explain the doctrine of ultra vires under the Companies Act 2013. What are the consequences of ultra vires Act of Company? So we have seen doctrine of ultra vires. You can completely present that doctrine, whatever things you recall. Like you have to be thorough with the meaning of ultra vires. Ultra vires means beyond their power. Whatever is written in your MOA, AOA, that much only is the power that a company has. In excess of that, if something you are doing, the company is doing, then you can say it has availed, like it has wailed of the ultra vires. Okay, let's see what they have given. The meaning of the term ultra vires is simply beyond their powers. Legal phrase ultra vires is applicable only to acts done in excess of legal powers of the doer. So whatever legal power you have been given by your memorandum, by the Companies Act, that much only you can do. The presupposes that the powers are in their nature limited. Okay, so the powers are limited, whatever is written. If you want to add some things, you can write in the MOA, you can write in the AOA, and then you can exercise those things. To an ordinary citizen, law permits whatever does the law not expressly forbid. So if you are a normal human being, whatever is not illegal, you can do all those activities. Same thing is given. To an ordinary people, ordinary citizen, law permits whatever the law does not expressly forbid. So you can write whatever is legally permitted, people can act accordingly. This point is not much relevant over here. So if you want, you can skip this point also. Now, it is a fundamental rule of company law that the objects of a company, as stated in its memorandum, can be departed from only to the extent permitted by the Act, thus far and no further. So, it is a fundamental rule of the company law that if your objective is written in your memorandum of association, that much only objectives you can follow. And that objective should also be compliant, should be allowed in your Companies Act 2013. In consequence, any act done or a contract made by the company which travels beyond the powers not only of the directors but also of the company is wholly void. So if you're doing any such activity which is beyond the power of the director, also like beyond the power of the directors or beyond the powers of the company, then it is going to be called as void and inoperative in law. Inoperative in law, and is therefore not binding on the company. And if you do such activity, you are getting into transaction with foreign companies. But in your MOA, it was not written that you can get into transaction with foreign company. So now this particular transaction you have entered into with foreign company is void and inoperative in law. On this account, a company can be restrained from employing its funds for purposes other than those sanctioned by the memorandum. You can't use the money that is there in your company for anything that is not mentioned in your memorandum. Likewise, it can be restrained from carrying on a trade different from the one that is authorized to carry. So if anything that is written, I gave you example while I was teaching you the example of Bata. Right? If Bata has not written in their MOA that they can start selling the clothes also, then they don't have the right of selling the clothes. Okay? Is the first point clear to you people?
Yes, ma'am.
The impact of the doctrine of ultra vires is that a company can neither be sued or sued on an ultra vires transaction, nor it can sue on it. So you have to remember this point also is very much important. You can't sue a company because if it is not written in your memorandum and if you are impacting the doctrine of ultra vire, if you are unveiling this veil, you're taking off the veil of ultra vires, then you can't say that we can sue other people or other people can sue you. Since the memorandum is a public document, it is open to public inspection. So few points, I'll just summarize this for you, what all things are written over here. Memorandum is your public document. It is open to view for everyone. So whichever company is getting into transaction with you should be considered that they have read the memorandum of association and articles of association. So even if after reading, in spite the reading of this MOA and AOA, if you enter into a transaction with any company who has like taken off the veil of ultra wires, who has done something which is not written in the objective, you cannot enforce against it. You cannot sue that company. Okay, these points are mentioned over here. Also, one example is given. If you have supplied goods or performed service on such a contract or lent money, okay, we'll have to read over here. Therefore, when one deals with a company, one is deemed to know about the powers of the company. If you're transacting with any company, you get registered into any company. So it is considered you know everything about that company. If in spite of this, you enter into a transaction which is ultra wires the company, you cannot enforce it against the company. Even if you have read everything of memorandum of association, it is written company cannot enter into a foreign transaction. Still a foreign company is getting into a transaction. You supply some goods to Indian company. Foreign company supplies some goods to Indian company or does some service for the Indian company. You cannot obtain payment or recover the money lent. If ABC Inc. does any transaction with XYZ Limited. So this is a US company and this is an India company. But in the MOA, it was written, in MOA, it was not mentioned about foreign transactions, right? Foreign transaction. Still you entered into this transaction. This is of supply of IT service, right? They are going to take some service from ABC Inc. But it was not written. So now ABC Inc. cannot say give us the payment for this service. It was not written in their MOA. How did you enter it? It is considered when you are entering into a company's transaction, you have read the MOA. Entirely you have to read the MOA before you enter in the transaction. But if the money advanced to the company has not been expended, the lender may stop the company from parting with it by means of an injunction. This is because the company does not become the owner of the money, which is ultra wires the company. So if some money has been given to ABC Inc. already and some services have been given, so that will be settled down. But if some advance money is given and you have not used that money, so then you have to give back that money. Okay, is this point clear?
Yes, ma'am.
As the lender
Yes,
remains the owner, sorry, doubt?
No, ma'am.
Okay. As the lender remains the owner, he can take back the property in specie. If the ultrawires loan has been utilized in meeting lawful debt of the company, then the lender steps into shoes of the debtor, paid off, and consequently he would be entitled to recover his loan to the extent from the company. If you have given some loan, ABC Inc. gives some loan to XYZ company, so that is also to be recovered. You can say that is debtor paid off. An act which is ultra wires of the company being void cannot be ratified by shareholders of company. Shareholders of the company cannot make good that particular transaction. Sometimes act which is ultra wires can be regularized by ratifying it subsequently. For instance, if the act is ultra wires, the powers of the directors, the shareholders can ratify it. If it is written in the particular MOA that if something is ultra wires and you can regularize it, you can correct that error, then you can correct it. Shareholders and directors can correct it. If it is ultra wires articles of the company can alter the articles. If you have done something wrong which was not mentioned in articles of the association, then you can change the articles of association. If act is within the power of company but is done irregularly, shareholder can validate it. If it was in the power of company but it was not properly done, so that type of transactions also shareholders can validate. Shareholders can correct that transaction. Okay. In the ultra wires, if you mention till here also, this point also, that will be enough. Is the doctrine of ultra wires clear? We have almost revised the doctrine again. let's go ahead. Now, doctrine of indoor management. So I hope these direct questions you will be answering. Like, we shall not take much time over here. So doctrine of indoor management, we know that it is considered that you have read all the documents. But even though if you have read all the documents of the company, your articles of association and memorandum of association, it shall be assumed that you don't have the internal information. People are not supposed to have the internal information. So if anything goes wrong due to internal issues of the company, person is not bound by that activity, is given in your doctrine of indoor management. I'll just sum it up for you. We'll just read the first lines of it. According to this doctrine, indoor management, the outsiders dealing with the company, though are supposed to have satisfied themselves regarding the competence of company, enter into a proposed contract, are also entitled to assume that as far as the internal compliance to procedures and regulations by companies concerned, everything has been done properly. What a person will be considering, if I am doing some transaction with Reliance, so what I will think, okay, they are complying with all the regulations, they will be filing all the returns. I will not go and check in their association how many years of return they have filed. If it is freely available, I will check it. But there will be some policies that Reliance is going to launch the product in 20 days. This is an internal thing that can happen in 25 days also, or within 15 days also. That is an internal thing. I will consider, okay, they will launch it within a month. They are bound to examine the registered documents of the company and ensure that the proper dealing is not inconsistent therewith. But they are not bound to do more. So what we can do, if I am getting into transaction with Reliance, I have to read what Rushali has to do. Rushali has to read MOA, Memorandum of Association, Article of Association, then your financial statements, audit report, then your annual report, all this freely publicly available document I will read. But I will not do more than that. I will not get into internal affairs of the company. That is their company's lookout. I am not one who is going to check that. They are fully entitled to presume regularity and compliance by the company with the internal procedures are required by the memorandum and articles. I will say, if it is written in the memorandum that the people of the company, Reliance company, are going to report it to the managers within 2 months, so they are going to report in 2 months. I will not go and check, okay, if they have reported or not. I am just a shareholder. I just want to invest in that company. So I will not get into much of the internal affairs. This doctrine is the limitation of constructive notice. This point you have to mention when it comes to doctrine of indoor management. It is a limitation to constructive notice and popularly known as the rule let down in the celebrated case of Royal British Band versus Turkant. Thus, the doctrine of indoor management aims to protect outsiders against the company. So here, if something is wrong going on in the company, outsiders will be protected because they don't know about the internal affairs. So indoor is your internal. You can relate it this manner. Okay. Is this doctrine clear?
Yes, ma'am. Clear.
Now, what they have asked in the question, explain the circumstances in which an outsider dealing with company cannot claim any relief in the doctrine of indoor management. So whatever are the limitations of doctrine of indoor management will be written over here in this question. Where you can't claim the relief, that means where doctrine of indoor management is restricting you, limiting you. So limitation is actual or constructive knowledge of irregularity. You can't have the exact knowledge of irregularity, or you got some information from some person. Then you can't say that I was considering that the internal affairs are going well. You knew from someone else, right? Let's see what they have given. The rule does not protect any person when the person dealing with the company has notice where actual or constructive of the irregularity. You just have an idea that the internal affairs of the company are not working very well. So that time you can say you have a knowledge of irregularity. You heard it from somewhere. some people were talking near the office somewhere that something is going wrong in the company. So you have just an idea. Then here you can't take help of doctrine of indoor management. Okay. In Harvard versus Patent Ivory Manufacturing Company, where the directors could not defend the issue of debentures to themselves because they should have known that the extent of which they are lending money of the company required the assent of general meeting, which they had not obtained. So here, if the directors of the company have given some loan, it is considered that a meeting, general meeting has to be held, and whatever amount you have to give it as a in the manner of debentures, that is to be decided in the general meeting. There is some specified limit that I can issue the debentures of 5 crore only, but the directors issue 10 crore debentures. That is not allowed. For this, if you want to do 10 crore, you have to take a general meeting. You have to take the consent of all the members in the general meeting. Likewise, in Morris versus Cansen, a director would not defend on allotment of shares to him as he participated in the meeting, which made the allotment. His appointment as a director also fell through because none of the directors appointed him was validly in office. So, if your director says that I have been allotted some shares, but that director, when this director was appointed, remaining directors were not present. A says, I have been given shares of Reliance. But A is not the director because all the other board members, Mukesh Ambani, Neeta Ambani, and Akash Ambani, Anant Ambani, all these directors were not present. So how we can say this Anil Ambani has become the director? You can't say, and the validity of the shares he is holding of Reliance is also invalid. Because here it is important for a director to be appointed that other directors should be present in the office, but they were not present. They were on a holiday, so they did not come to the office on that day. So now behind them, Anil Ambani can't come and say, I have the shares of Reliance. Who gave it to you, the shares? Who said that you are the director? Okay, is the first point clear? I have to check with the chat again and then come to you people. Okay, there is some message. We should memorize the case law names. No, no, not required. I am just giving you reference. If you mention only this much also, actual or constructive knowledge of irregularity, that is also enough. You just have to mention that. If you remember any of the case laws, then only write it. Because the syllabus is too much for you. You can't remember all those things. Majorly, you have to write what limitations are there. So the first limitation is actual or constructive knowledge of irregularity. Second limitation is suspicion of irregularity. You have a doubt about irregularity. That you will be mentioning. Then next is forgery. If you know that some documents have been forged, share certificate issued to you has been forged and issued to you. So that time you can't take that I was not aware that the sign is fake over here. You were aware about it. Some forgery has been done. You are aware about this. So if you have got a share certificate and the sign is fake over there, you can't say that the sign is fake or real. I was not sure. Even though you were not sure that the sign is forged or it was done by some other person, you will have to give that share certificate back because the sign is fake. Okay, the sign is forged. They have given an example over here. I hope that is the same example. The plaintiff contended that whether the signature were genuine or forged was a part of the internal management, and therefore company should be estopped from denying genuineness of document. But it was held that the rule has never been extended to cover such a complete forgery. Your indoor management, this doctrine does not cover forgery. It is not written anywhere that if some fraud is done or some forgery has been done, then also you can take the support of indoor management. It is not written. So here you will not take the support that sign is there of the director. I don't know if director signed or some other person signed. I am not aware. This is internal affair. You can't take the help of the blanket of indoor management. Okay. Let's move to the case study based question answers. A and assessee had large income in the form of dividend and interest. In order to reduce his tax liability, he formed 4 private limited company and transferred his investment to them in exchange of their shares. The income earned by the companies was taken back by him as pretended loan. Can A be regarded as separate from private limited company? Can we say that A is an assessee, he is earning some dividend and interest, but the dividend and interest that he is earning of 10 crore. So what he does, he splits away all the money in 4 companies: B Limited, C Limited, D Limited, and E Limited. Right? He makes 4 companies. Now he gives them 2 crore shares. He gives him 2 crore shares. Here he gives 3 crore shares, and here he gives 3 crore shares. Now these companies, what they do, whatever interest and dividend is earned, whatever money is earned, they give it back to Mr. A. Right? Interest and dividend earned by all these companies is given back to Mr. A. Right? All these interest and dividend is given back to Mr. A. That means they give a loan to Mr. A. Now, can we say Mr. A is different and B, C, D, E Limited are different? What do you say here? Are these companies different from the person? At least you can speak up. Is the company and the person Mr. A Limited different? No. Okay, one has answered. Now, it is not different over here because he is doing this activity to save the taxes. Lakshita, how is it different? The person and company, how they are different? Explain. Not with a separate legal entity kind of thing. And also, can we say here that they have a separate legal entity? The House of Lords in Salmon versus Salmon and Company laid down that the company is a person distinct from separate from its members. It has a separate legal entity and therefore has an independent separate legal existence from its members who have constituted the company. So A Limited is different, B, C, D is limited. But certain conditions, certain circumstances, the separate entity of company may be ignored by the courts. What will court say? You are saying that company is different and we are different, but in some cases I am not going to consider that company and the people who are running it is different. When that happens, the courts ignore the corporate entity of the company and look behind the corporate facade, look behind the actual face, you can write actual face, and hold the person in control of the management of its affair liable to the acts of the company. Where a company is incorporated and formed by certain persons only for the purpose of evading taxes. What A Limited did over here, if you have 10 crore income, you will be liable for 37% of surcharge. In income tax, there is above 5 crore, you have 37 crore of surcharge. So now what he did, he tried to split it over here. Right? For one person, the surcharge is 37%. Now, if the companies are developed, for companies, the rate of interest is maximum 12%, right? Over 10 crore. 1 crore above, you have 7%. And if the income is about 10 crore, so it is 12%. So what he will say that on 10 CR, if I pay 37%, that will be 3.7 crore. Right? Instead of paying that, I will pay on 2 crore, whatever interest will be earned, whatever income will be earned. On 2 crore, I'll pay 7%. That will be beneficial for me. Still, if he pays 7% only, he will be saving the amount over here. What does 2 crore into 7% tell me? Till I take the marker. Yes, fast. 1.5 crore or 1.4 crore? Sorry, not 1.4 crore. It's 70% I was taking. Yeah, 14 lakhs. Again, here it will be 14 lakhs. Right? Here it will be 21 lakhs. Here it will be 21 lakhs. Now, if we consider the total of all these, still it is very much less than your 37% on 10 crore. Right? How much it comes out to be? 28 plus 42. right? Then you have only 70 lakhs to pay. And where this is 3.7 crore. 3.7 crore and 70 lakhs, huge difference is there. Am I clear? So in order to save this money, you can say something is written corporate way. Yeah. So in order to save all these 3 crore rupees, what he thought A Limited, Mr. A, what he thought, I will not keep it in my account. I will just distribute the shares, transfer the shares to 4 companies. Companies have a lower surcharge rate. I am an individual. All the income is coming to me. So I have to pay 3.7 crore. But if my companies will be paying the tax on this, I will only have to pay 70 lakh rupees as a tax. That is your surcharge amount. I am not considering tax over here. I am just giving you an example of surcharge. You will be learning in your inter what is surcharge. Surcharge is the extra tax that the company that the government takes from you for earning more income. So in this case, you will see, to evade the taxes, to prevent from paying higher taxes, this type of things are done by people. When a company is incorporated and formed by certain persons only for the purpose of evading taxes, the court have discretion to disregard the corporate entity and tax the income in the hands of appropriate assessors. So what here courts have decided that companies are not separate from the person who is running the company. In this particular case, Mr. A, the assessee, will be considered for having the 10 crore income, and he will pay the tax, he will pay the surcharge at 37%. They have also given one more case law. It is in the similar manner. So you can take this. I'll just go to conclusion directly. In the instant case, 4 private limited companies were formed by A, the assessee, purely and simply as a means of avoiding tax, and the compliance were nothing more than facade of the assessee himself. So the companies were nothing, just a face ID for Mr. A, the assessee. They were just acting for Mr. A. Therefore, the whole idea of Mr. A was simply to split his income into 4 parts with a view to evade taxes. No other business was done by the company. Hence, A cannot be regarded as separate from private limited companies he formed. Okay? Is this clear? This is your facts of the case. Till here, your facts of the case. Then from here, therefore, here your conclusion starts. Here your conclusion starts. And the above things will be your provisions that you have mentioned, case law that you have mentioned. Is this question clear? Go and check again. Okay. Let's go to the next question. Sound Syndicate Limited, a public company, its article of association empowers managing agents to borrow both short and long-term loans on behalf of the company. Mr. Liddell, the director of company, approached Easy Finance Limited, a non-banking finance company, for a loan of 25 lakh in the name of company. Lender agreed and provided the said loan. Later on, Sound Syndicate refused to repay the money borrowed to the pretext that no resolution authorizing the loan has been actually passed by the company, and the lender should have inquired about the same prior such loan, hence the company is not liable. Analyze the above situation in the terms of provision of doctrine of indoor management under the Companies Act 2002 and examine whether the contention of Sound Syndicate Limited is correct or not. Now, what happens over here? There is a company called as Sound Syndicate Limited. I'll write it, SS Limited. Now, it has been written in MOA and AOA. Okay, it's only written in AOA. So let's just take it AOA. It has been written in the AOA that the directors can borrow, the managing agents can borrow short and long-term loans. Amount is not given. The term is given. How long you want to keep that loan, that is given here. Your duration is not, duration is given. Amount is not specified. What you can take? You can take short-term loan or long-term loan. right? That much is only given on behalf of company. So Mr. Little, what he did, he took a loan from the bank, from a non-banking finance company, from an NBFC. How much he has taken the loan? 25. Now, the lender, syndicate, EC Finance Limited will come to the company and tell, give us the money that you borrowed. Now your time is over. Give back the loan. Sound Syndicate says, we will not pay you the money because there was no resolution passed. This 25 lakh borrowed by Little, Mr. Little, this was without resolution. So if you want to do any activity, you have to pass a resolution, but some powers are given already in your AOA and MOA. So for some small things, you don't have to pass a resolution. So what the members say of the company, that there was no resolution authorizing such loan. We did not authorize, we did not say to take such loan, right? Lender should have inquired, and what the company's members say, you should have inquired that do you have a resolution, valid resolution or not, and how you are taking the loan. All these questions you should have asked Mr. Little, and the company says we are not liable to pay such loan. So now, is it considered, is it deemed that the person who is the lender, the non-banking finance company, Easy Finance Limited, should have read your AOA Articles of Association? Articles of Association is a public document. So what we will say, it is considered that you should have read the Articles of Association. But in the Articles of Association also, it is not mentioned how much amount the managing agents can borrow. It is just mentioned that the managing agents can take some loan, etc. Now, let's see how they have given. First, we will be quoting Doctrine of Indoor Management. According to this doctrine, person dealing with the company need not inquire whether internal proceeding relating to contract are followed correctly once they are satisfied that the transaction is in accordance with memorandum and articles of association. What it will see, that it is written in the doctrine, in the articles of association, your managing agent, your directors can borrow the loan for short term or long term. That is written. So bank, the Easy Finance Limited just read that thing. Okay, it is written in the articles of association, he can take the loan. So he is taking the loan. But it was not written that for any amount resolution needs to be passed. Stakeholders need not inquire whether the necessary meeting was convened and held properly, or whether necessary resolution has been passed properly. They are entitled to take it for granted that the company had gone through all the proceedings in regular manner. Now here, stakeholder means your Easy Finance Limited. Now, Easy Finance Limited will not call and ask Mr. Little that have you taken the resolution? Have you passed the resolution? Was the board meeting done? Was the general meeting done? What they will say, this is their internal matter. Why should I interfere in that? Doctrine helps protect external members from the company and states that people are entitled to presume that internal proceedings as per the documents submitted with registrar of companies. So it is presumed that the companies are complying with all the internal proceedings. Thus, what happens internal to a company is not a matter of public knowledge. Whatever is your insider things, whatever internal affairs are there, that is not to be given a public notice about it. An outsider can only presume that the intentions of company but do not know the information he or she is not privy to. If you are not authorized, your non-banking finance companies, Easy Finance Limited, he is not supposed to check that if the resolution is passed, was the meeting held. These are internal matters. How he will check? If not for the doctrine, the company could escape creditors by denying the authority of officials to act on its behalf. If not the doctrine, if you are not taking the support of doctrine of indoor management, company could escape the creditors. Company will take escape from the creditors by denying the authority of officials to act on its behalf. They will say, we don't know, we were not, we did not authorize Mr. Little to take such loans from the company. So now in this question, what will be the conclusion? In this given question, Easy Finance Limited, being external to the company, need not inquire whether the necessary resolution was passed properly. He is not required to see, did you do the meeting? Did you pass the resolution? All these are your internal affairs. Banks or the financial companies will not come and ask you. Even if the company claimed that no resolution authorizing the loan was passed, company is bound to pay the loan to Easy Finance Limited. Even if you are saying that this company, even if you say that directors were not given the permission, the authorization was not done in a resolution, etc., you will not deny the loan. You will have to repay back the loan. Okay. Is this point clear? Is this question clear to you people?
Yes, ma'am.
Okay. Let's go ahead. Naveen incorporated a one-person company, making his sister Navita as the nominee. We have already seen a similar question in your test paper, but let's discuss it again. Naveen incorporated a one-person company, making his sister Navita as the nominee. Navita is leaving India permanently due to her marriage abroad. Due to this fact, she is withdrawing the consent of nomination in the said one-person company. Taking into consideration the following provisions of Companies Act 2013, answer the question given below. So, if Navita is leaving permanently India, it is mandatory for her to withdraw her nomination in the said one person. Give me 1 second. Yeah. So Naveen incorporated a one-person company. So Naveen has made whom the nominee? Navita, the sister. Now, this sister got married and now she's leaving India. So, if some person is leaving India permanently and if Navita is leaving India permanently, it is mandatory for her to withdraw her nomination. Is it mandatory? Yes, it will be mandatory because she is not going to be the resident. She will not be in the in the country of India, and that is why it is compulsory for her to withdraw. Yes, it is mandatory for Navita to withdraw her nomination in the said OPC as she is leaving India permanently, as only a natural person who is an Indian citizen and resident in India shall be nominee in one-person company. So if you want to be a nominee in the company, here they have not written the provision, but when we will be writing the answer, we will be writing 2 lines only. Nominee has to be citizen of India and resident of India, right? These things they have to write over there. Okay, this provision you have to quote it. In the next one, what they have asked, if Navita maintained the status of resident of India after her marriage, then can she continue her nomination? If she is maintaining the resident of India status, then she can continue undoubtedly. Yes, Navita can continue her nomination in the said one-person company if she maintained the status of resident of India after her marriage by staying in India for a period of not less than 120 days during the immediately preceding years. So how she will maintain the resident of India status? She has to stay in India for not less than 120 days. So, or you can write for 120 days or more. Okay, is question number 7 clear?
Yes, ma'am.
Okay. Let's go to question 8. Explain the following whether they are correct or incorrect along with reasons. A company being an artificial person cannot own property and cannot sue or be sued. That is incorrect. A company is a separate legal entity. It is legal or judicial as it is created by law. It is a person since it is clothed with all the rights of individuals. You will say that company takes the form of an individual and it takes the shape of an individual. Further, the company being a separate legal entity can own the property, have bank account, raise loan, incur liability, enter into contract. Even members can contract with the company, acquire right against it or incur liability. It can sue or be sued in its own name. Company can sue other people or other people can sue the company in their own name, in the company's own name. It can do everything which a natural person can do except be sent to a jail, take an oath, marry or practice a learned profession. Hence, it is a legal person in its own sense. If you want, you can skip this thing It can do everything. This part you can skip also. But if you remember, you can write it. So this point is important, that it has a separate legal entity created by law, legal judicial person created by law. It takes the rights of all as an individual, and you can sue the company, and the company can be sued by other people also. Okay, that was your A part. Then the B part, a private limited company must have minimum of 2 members, while a public limited company must have at least 7 members. So that is correct. We have already read that a private limited company, if you want to construct a private limited company, basic requirement with respect to construction of a company is there should be 2 members in a private limited company and 7 members in a public limited company. In case of a public company, any 7 or more person can form a company for any lawful purpose by subscribing their names to memorandum and complying with the requirements of the act in respect of registration. In exactly the same way, 2 or more person can form a private limited company. So instead of writing this, what you can say is, a private limited company should have minimum 2 members who are subscribing to the memorandum, and in case a public limited company is to be formed, you should have 7 or more members. At least 7 members should be present. Is this chapter clear to you people?
Yes, ma'am.
All the questions given in the RTP of this one I've covered in the test. If though it is not covered and you want me to explain again, we can do that in the next class also. Okay? I hope this all questions are clear to you people. Okay. So we'll stop for the Companies Act now.